Uh, Very good afternoon to everybody. A warm welcome to Judge Fabian Hoffmann. This
Hello.
is this is an Ox First webinar where we will be discussing Frand valuation and royalty rate determination, and where we will look especially on the issue of how to distribute, how to deal with global Frand rates and distribute perhaps the power among various jurisdictions when it comes to Frand rate setting. Judge Fabian Hoffmann has, in that respect, offered new ideas and new suggestions as to how to go along in addressing the international distribution of Frand rate setting. And it's my big privilege that we are one of the first to actually share these new ideas and suggestions and vision for a global world order on intellectual property and standard essential patents with with our colleagues and audience from the IP and competition law sector. So for those who don't know Oxfirst, I started Oxfirst nearly 15 years ago while I was still a full-time academic in the University of Oxford, together with my students, and we are economists and we focus on the valuation of IP and on Frand royalty rate determination, and we provide also economic assessments for policy purposes. We are running a big conference end of June. If you have any interest, please let us know. It is June 26 and 27 in Amsterdam. At this conference, we will be looking into the Unified Patent Court, into artificial intelligence and IP, as well as on Frand and standard essential patent matters. We expect an international audience from the judiciary, from policy circles, and from the high-tech industry. If you're keen on getting involved, please give us a shout. You can find out more on the website of Oxviews Limited, not Oxfirst, because it's I thought it's better to separate that out. With that very brief introduction, I'd like to now present Judge Hoffmann. Judge Hoffmann has been now with the German Supreme Court, which is not called Supreme Court in Germany, but the Federal Court of Justice, the Bundesgerichtshof, since 2010, so quite a while, and is a very experienced judge. Before he joined the Bundesgerichtshof, the Federal Court of Justice in Germany, he was in Frankfurt in the High Court, which the higher regional court, the Oberlandesgericht. And he is from Frankfurt. As you can see in the background is the skyline of Frankfurt and the European Central Bank. And he was also working as a lawyer in the Supreme Court in Karlsruhe already at an early stage of his career. That's embarrassing. Zoom is sending me, confirm you're really speaking English. I apologize. My English is so dodgy that you need to confirm that this is actually English what I'm speaking. Yes, it's English, a Germanized version of English, but we're trying to do our best here. And I met Fabian when we were working together in Brussels for the European Commission, trying to come to grips with an expert report on standard essential patents, which turned out to be a huge drama, but we still had an interesting contribution and we developed new ideas on how to value sets. And I'm forever thankful to Fabian for his contributions on the present value added approach. And as we were preparing for this webinar, I already benefited a lot from Fabian's experience as a judge, where I thought, well, things could be in that and that way. And Fabian said, no, this is not how it's done in practice, or this is not really the situation. And that was very interesting for me to learn from that, because obviously I have a different background, and this was already really interesting. So when we came up here with this topic, we had a meeting we met in Warsaw earlier
Yes.
this year, where I said what Fabian has to offer to the world is exciting, and I really congratulated him on a constructive approach towards looking into the issue of how to address questions around anti-suit injunctions and the global distribution of power between various countries when it comes to deciding on IP, on patents, on standard essential patents at an international level. I think at the core of the problem is that many of our international treaties on IP, the Berne Convention, were created in the 19th century and followed a nation-state order with national territorial limitation was the baseline of all of what they did. And that was absolutely fine, I guess, or kind of still okay in the 19th century. But it is not okay anymore in the 21st century, where international economic integration and globalization has meant that with a single mouse click, you can be connected to people on the other part of the world and trade and undertake business worldwide. And in this context, having still a fully nationally, territorially limited patent system has meant that we haven't followed up as quickly with the technology innovation that the patent system is supposed to incentivize. So we need some new ideas and new thoughts. And it seems from what Judge Hoffman sent to me, and he sees very much the challenge here, that it is currently the one court that is the fastest, the race to the court, that will decide on an international level what's gonna be the situation. And I think this may be considered unfair. And there may be other ways of distributing decision-making processes between nations. And I have said now an awful lot. So Judge Hoffman, in patent law, we often talk about problems and solution. In this specific instance, I have started to try to sketch out already the problem, but where do you see the problems, and what motivated you to start your research and propose new ideas on how to address the international distribution of front rate setting?
Yes, thank you very much, Roya, for giving me the opportunity to show my thoughts in this. The problems concerns the determination of a frand rate for products that are distributed by an implementer in more than one country, as usually the case, but where a court is only competent for one of these countries. Different principles here come into conflict. The jurisdiction of a court is generally limited to its own territory. One might therefore think that if a product uses a standard essential patent in several countries, the court should nevertheless only determine a frand rate for the country in which it has jurisdiction. Well, however, this would mean that the SCP holder would have to enforce its rights separately in each country. The mutually agreed SCP license agreements already show that both sides consider such an approach to be unreasonable and an unfair burden on the SCP holder side. For this reason, such license agreements are regularly agreed with global scope, often with different license rates for different territories. Once an agreement has been reached, no territorial gaps should remain. From a practical point of view, this is entirely understandable, correct, and fair. That's why the courts that have ruled on our frand rates so far have generally set one or more frand rates for all territories covered by an SCP family. I consider this principle to be completely justified. However, it means that a court indirectly determines the license terms for a product in a foreign territory, a territory for which it has no jurisdiction. Now, this problem gets worse when several court cases aiming to set frand rates are filed at the same time in different countries. If the first court sets a frand rate and thus the global license terms, one might think that this settles the dispute before the second court. However, this would mean that the speed with which a judgment is handed down becomes relevant to the outcome of the legal dispute. A fast court would determine the Frand rate worldwide, while a slow court ultimately has nothing left to decide. Such aspects should not play a role in court proceedings. Even though a court should decide quickly, it should nevertheless be able to take the time it needs to do so.
If I may say, if we go like for the fastest, isn't there maybe then a risk that this gets a bit sloppy, that you don't have time to think things through? I see in the UK we spend a lot of time on one judgment, and we are not the fastest in the UK at all, but you really get then judgments where you have a lot to read and to digest. But they would always lose out then. And then, so how would we do that? You don't want the fastest ones to win. You want the ones who have interesting ideas. You want to have an equitable distribution. You want to give low and mid-income countries a chance also to contribute to the debate. So what ideas come to your mind and to address the question? And what would be, how could we go ahead, generally speaking, and where would you see the first step?
Yeah, well, I think an improvement could be achieved if the license terms determined by the court contain a provision allowing for adjustment in the event that other courts in other countries also determine a Frand rate for a patent in the SEP field family between the same parties later on. Such an adjustment could follow a three-step model, which I would like to present with some slides I've prepared.
Mm-hmm.
So you see my slides?
Yes, we do.
Okay. So I've got some problems here.
We see
yeah.
global Frand rate setting in 3 steps.
Yeah, exactly. That's right. So the first step would be that is something that is actually similar to to the current practice. A first court determines the Frand rate not only for its own country, but for all countries for which parties would conclude a license agreement if they would do it mutually by consent, which means generally globally for all countries covered by the patent family of one or more SEPs being used and maybe being used and maybe violated. As in previous practice, such as in the case Unwired Planet versus Huawei, the Frand rate may be determined differently for different territories. The only difference in my model from previous practice is that these Frand rates that are set by a first court may be subject to adjustment in accordance with the next 2 steps, in which I will now describe, and which take into consideration that one or more courts later on also determine Frand rates for their own country, and if so, for other countries as well.
Mm-hmm.
Now, that doesn't sound like a big change, but the key difference is that the license terms shall take future developments into account. Now, the second step is that a court also determines a Frand rate, at least for its own territory and possibly also for other territories. However, it would not determine a different Frand rate for territories in which courts have already determined a Frand rate for their own territory. The principle of comity comes into play here in that the second and all subsequent courts fully respect the Frand rate determinations of other courts insofar as the territories of those courts are concerned. As an expression of this principle of comity, the proviso attached to the license conditions set by the first court also leads to the adjustment that its Frand rate determination no longer applies to the territories of the second and all subsequent courts once such court decisions have been issued in the respective territories. This is the first expression of the proviso I referred to earlier in the relation of the first step. And furthermore, the second and all subsequent courts may, just like the first court, determine Frand rates for all other territories in which no court has yet determined a Frand rate for this patent family between these parties. Each court is respected to the same extent by every other court. No court takes precedence over another court in another country.
If I may add something here, because you mentioned Unwed Planet versus Huawei, when this case went up to the Supreme Court in the UK, there was a huge debate about a doctrine in English law, which is the form non-convenience, which has absolutely nothing to do with civil law or German law, because it stems from a different legal history. So as you know, England and Scotland have never been massively in love with each other, to put it mildly. I have lived in Scotland a few years. I was in Scotland during the Scottish referendum, whether we should leave, whether Scotland should leave the UK altogether. And already at the time, why form non-convenience really came up was a desire from the Scots to have more independence from London. And they came up with that question if over some Scottish issues the English should really be deciding. And then this whole question of where you should be deciding and how you should be deciding was established in English law. But behind it is a centrally old struggle for hegemony. And when North America was conquered, then they took with them the principle of form convenience. And when you go to Canada, the English-speaking world of Canada has that doctrine of form non-convenience, but not Quebec, because it has a French history, which had no idea about this. It's different civil law, different issue. So if I look at the legal history and how it evolved, it was always a struggle for power, for self-determination, for who can decide on a certain question and who cannot, and what are the underlying principles. I think that centrally old struggle between Scotland and England has taken a completely new dimension when we are now looking at the international economic order. And when the English decided to come to grips with that question, they obviously referred to their own English legal tradition. And now, from a German tradition, it is very interesting to see what input you have to offer from your legal history and from how you have evolved as a nation and also as a legal system. So I think this is a completely new approach that you're offering, which is thinking outside of this traditional approach. And it would perhaps be interesting then to hear what the French have to say to this, with what I recall the French call the something doctrine d'autrui or something along those lines. I don't know. I'm not clearly, but they have their own thing again. So, and I recall there were issues when the French started to intervene and figure out from their, no, stipulation d'autrui or some, I don't know, any French people on this call, please just correct me. And then you had the clash between this something d'autrui and the English non-convenience, and this was like bang. And so, and obviously you would have to probably figure out first how on earth these different laws go together or don't go together. But what I think is interesting here is that we stay out of that. We're not trying to make the French English or anything along those lines. We're just trying to find another way how we can establish international cooperation rather than racing as quickly as we can and walk over someone else.
Yeah,
If I
but
may say that in a very sloppy way. That was what I thought was interesting.
Well, first of all, you remind me that I didn't mention the usual disclaimer. I'm only speaking on my own behalf and not on behalf of my court or my country or anything. I couldn't say whether that's a German approach or whether it's just my approach or whoever approach it is. It is the form of non-convenience we mentioned before, it is nothing that really could work out well, because it would mean that the SCP holder would have to enforce its patents on every in each court and territory separately. Now, I would like to show a system where you can have a global Frand rate setting, but also have different court rulings and show how they could be adjusted. And as I already mentioned in the first two steps, you have a global Frand rate setting by the first court, and then you have a Frand rate setting by the second court. And this already leads to the fact that both for those two territories, the Frand rate settings are adjusted. The first court accepts the Frand rate setting by the court of the territory B, and the second court it accepts the Frand rate setting of the territory A. Now, the interesting point is, what do you do with the rest of the world? And this I would like to show you now with a third step that comes into play. There's no problem for the territories in which a court has determined a Frand rate, because their decisions will be reciprocally respected in this respect. For the other territories, the different Frand rates should be mathematically aligned. One way to achieve this alignment an easy way would be just to calculate an average. You could simply take the average of the two Frand rates, which would then apply to both sets of license terms determined by the courts between the parties. But that would mean that the court of a small country with a small market would ultimately determine the Frand rate for all third countries in the same way as the court of a large country with a large market share. And to say frankly, that would probably not be fair. It could even encourage abuse. It is therefore better to calculate a weighted average. To calculate the average, therefore, each Frand rate determined by the court of a third for a third country is only given equal weight if the GDP, the gross domestic product of the countries to which the courts are attached, are the same, which is usually not the case. If the GDPs are not equal, the Frand rate determinations for one or more third countries are first weighted according to the GDP of the country of the respective court. The larger the GDP of the country to which the respective court belongs, the greater the weight of the Frand rate determined by that court would be for a third country. Only after such weighting shall an average be determined between the two or more Frand rate determinations made by two or more courts. This weighted average shall then constitute the common Frand rate to be paid by the implementer to the SCP holder for the use of the SCP family based on the Frand rates and license terms by the different courts in those territories where no country has yet, where no court has yet determined a Frand rate. Each Frand rate determination provides for this adjustment as a proviso in the event that subsequent courts also determine a Frand rate for the same SCP family between the same parties for other territories where no court has been yet determined a Frand rate.
Perhaps would it make sense to get an example here? Just
Yes.
to see this.
Yes, I want to show you
how this would work out.
Yeah, I'll show you an example.
Or am I jumping steps?
No. Exactly. Now I would like to show you an example, because it's just mathematically correct, but very abstract. And I think if you show an example, it comes clearer. Let's assume that a first court sets a Frand rate for its own territory, the territory A, at 17 cents. For the territory B, it sets the Frand rate to 15 cents. And for the territory C, it sets the Frand rate to 10 cents, whereby territory C can simply be the rest of the world. And now the second chord from the territory B also determines a global Frand rate. Therefore, it respects the determination of the chord of territory A and only sets and is bound by this determination and sets this Frand rate for territory A to 17 cents. For its own territory, however, the chord of territory B sets the Frand rate to 16 cents because it's its own territory. And for the rest of the world, which means territory C, it determines a Frand rate of 13 cents. Now, on the basis of this second Frand rate determination, the first chord's determination will then be adjusted so that for territory B, a Frand rate of 16 cents applies under its license terms and conditions and no longer just 15 cents. So that's the first proviso that the license terms set by the chord of territory A, that it will be for territory B no longer 15 cents, but 16 cents because the chord of territory B has set a Frand rate of 16 cents for its own territory. And now a weighted average has then to be calculated for both from both Frand determinations of both chords for the territory C, which means the rest of the world. Therefore, we assume that territory A of the first chord has a GDP of $3 trillion. I put the German billion, I think. That's why it says billion in the slide, but 3 trillion is probably more likely if you take the English trillion. So we say territory has a GDP of 3 trillion, and territory B, where the second chord belongs to, has a GDP of 6 trillion. Then the calculation would be as follows. The 10 cents from the first chord are multiplied by 3 trillion, and the 13 cents from the second chord are multiplied by 6 trillion. Both products are added together, and then this sum is divided by the sum of the both GDPs, which means divided by 3 plus 6 equals 9 trillion. The result of this calculation is a GDP weighted average of 12 cents. And due to the provisos in the license conditions determined by both chords, the joint Frand rates for territory A, B, and C are as follows. For territory A, it's 17 cents based on the determination of its chord, and for territory B, the rate is 16 cents, again, based on the determination of the chord in that territory. And for territory C, which would be the rest of the world, we have a rate of 12 cents based on the weighted average, whereby the last chord, which would in this example be the second chord, should of course immediately express this consequence in its judgment.
Mm-hmm. Mm-hmm. I mean, maybe, I don't know, I think maybe we could play around with this model and see also maybe how big is the market penetration of the products and where are they producing the products, or I don't know, maybe there can be still some, one could play around here a little bit maybe. I mean, this is certainly not wrong in terms of saying we look at the countries and how the countries shared up, but we could also look at how case specific maybe it looks up. And I recall this was in an earlier version, there were these questions involved also where I look at how
Yes,
does the
actually
market look like.
in Warsaw, I was thinking about what are the sales of the product. I skipped this alternative because it would be something that you could question about. How many products are sold? How much are they worth? And then you would have another trial on this question, and you would have that in different courts maybe. I think at this point of calculation for the territory C, where no court has set up a friend rate, it is necessary to have a clear calculation with based on clear facts, and that the best you can take, therefore, is the gross domestic product, where you have clear statistics that you can easily take, and it's really just a mathematical effort, only a mathematical effort that you have to take.
Sorry to ask again. I mean, in Unwired Planet versus Huawei, the court took a very strong, put a lot of effort into the question of figuring out where do you have your major markets, where do you have your other markets, and looked at that for various standards and on which the patents read on, and then came to a Frand rate determination and calculation on the basis of where are the major markets and where are the other markets, and also justified the fact that the UK should be taking a global rate because should be offering a global rate because UK was a major market in that case. So is there anything to learn from the thinking in this judgment in terms of dividing the world up into major markets and other markets, and sort of like think about the patent portfolio per se and where it is protected? Would that be in any way something you would consider in your approach?
Well, I consider it in the way that you have different friend rate settings for different territories. You could label them as major markets or minor markets. However, that's not important. The point is that you have to set up a global friend rate in order to have not the burden on the SEP holder side to enforce its patents in each territory. And of course, you have to reflect the fact if the market participants agree to different friend rates in different markets, although it's referring to the same SEP family.
Okay.
But let me also say something about how this model could be implemented in practice, because in practice, a first court that determines friend rates for territories other than its own, it just could add the proviso that the friend rates determined for other territories are subject to adjustment in accordance with the two further steps, which I already have laid out. The effect would be that this would better reflect the principle of comity, and it would strengthen the mutual respect among courts dealing with SEPs worldwide. But one should be aware that in most cases, this first stage would be the end of the process, since it does not happen very often that parties actually make the effort to bring SEPs from the same patent families with the same opponents before multiple courts. So actually, you don't have the need to really adjust according to the second and the third step if you do not have further judgments by other courts of other territories. The important thing is that you have the proviso in the first judgment that this would be possible if you do have further judgments by other courts in other territories, according to the model and the calculation in step 2 and 3. Now, however, this 3-step model already described, may also be helpful in other situations. Anti-suit injunctions, for instance, are based on the concern of a first jurisdiction that the SEP holder's action for an injunction in a second country could lead to a settlement of the legal dispute in the first country. If the ECP holder were to declare in advance that as a result of the injunction in the second country, it would only conclude license agreements with the implementer that contain a provision reserving the right to make adjustments in accordance with the 3-step approach as I was described here, then it would be clear for the first country that the legal dispute conducted there would retain its 100% effectiveness for the license terms in that country, and in addition would have proportional effectiveness for third countries. This could perhaps undermine the grounds for an anti-suit injunctions without the need for an anti-suit injunction. And that, I think, is something that parties could do in practice. Say, you don't have to fear that the judgment of the court in territory B would not have effectiveness, even if the judgment of the court in territory A would become beforehand, because we have this agreement that we would make an adjustment between those two Frand rate settings, even if the second judgment comes later on. And that's something that might avoid anti-suit injunctions. And if we have no anti-suit injunctions, we would have no anti-suit injunctions as well.
So this would be, I understand, we will have in our conference in Amsterdam, the European Commission speak about the latest decision of the World Trade Organization on this issue of anti-suit injunctions and the Chinese position on that matter. And maybe this could be a whole new approach again to sort of like find an amicable solution among various nations and among the judges in various nations, to sort of like see how to collaborate or exchange, or not sort of like step on each other's foot and de-escalate rather than escalate further the race to the court.
Yes, and what you mentioned a good and important point. It would be helpful if the judges from different countries would discuss such an approach or model, especially, or if another organization would specify more details, like how do you handle interest rates and how do you handle the points in time from which time which rate would have to be paid and so forth, and how would you, and it would probably also be mathematically a bigger effort if you set up a Frand leg as a lump sum and not as a running rate. But and that's something that you could try to discuss between different countries and different courts.
So further communication rather than complaints. I think we see in other areas, I don't know, tax law, also efforts of international division of labor. We have double taxation agreements. Even though I mentioned it, and you said, Fabian, we don't need an agreement at that point. It's enough if we have already some sort of understanding among the judiciary in various countries how we could somehow organize ourselves terms of who decides on what, rather than expose the courts maybe to the gaming of the parties who are going to cherry pick the court where they think they have the best chances, and then maybe put courts in competition against each other. This could be a way perhaps to take ownership again. I think, Fabian, is there anything that you would like to add, or should I open the floor to questions? Or
yeah, well, I was just looking at the chat, the questions in the chat. But if you want to give them the floor, that's
yes. I saw also we have a lot. We have 8 questions in total, which is quite a lot. Oh my God. So let's see. There's a question from Pippa Wheeler, Senior Litigation Counsel, HP. How do standard essential patent holders and payers avoid lack of certainty if rates are adjustable? How would you, have you thought about that yet? Or is this something we would need to still some research on? Or what do you think about that?
How do you, SAP holders and payers, avoid lack of certainty if rates are adjustable? They are only adjustable according to the fact that you have a second judgment. That's the only point where the adjustment could take place. And I think that's nothing that you have to worry about, because you know that this second litigation is going on, so you already know that there might be a second judgment. And I think, I mean, of course, you could say if we have a first judgment, then all other litigations shall stop. If the parties agree to that, that's good, that's fine, and then there's no need for adjustment. But if the litigation in the second country shall go on, then you need to, I think, then you need to have an adjustment, and the uncertainty arising from this litigation already is already in the room.
Mm-hmm. Then there's another question from Nicolas Saunders, who says, well, what if basically the different courts are using different Frand royalty rate methods and come to different conclusions on what the value of the rate should be? If one, for example, figures out the licensing rate only on the basis of comparables, and the other one figures it out on the basis of an aggregate rate, and they have different results, how do you split that then up? And how would you average that then? Is that something, how would you go along if you use different rate calculation methods?
Well, actually, in my model, I have no problems if they use different approaches to set up a rate. If one takes the top-down approach and the other one takes the bottom-up approach, that's not a problem. The point is that the result of this approach should be a rate, a running royalty, not loyalty, sorry, a running royalty per piece, and this must be comparable between the different rates. Like I said, one court sets up a rate 17 cents and the other court sets up a rate at 16 cents. It must be per piece in this case. And this must be comparable. It is no problem if one court takes it from this setup of comparables and the other court takes other grounds for its calculation and evaluation.
Mm-hmm. I also think, I mean, this is an early stage model. This is not yet something that has been researched and analyzed for years. This is a first sketch of ideas, which can certainly also still be further improved. There can be more added to. So I think the feedback that's coming in is perhaps also helpful to see where there can be still modifications may be made. Then there are lots of other questions also in another chat. Let me see. I don't know, Fabian, if you have already read these questions, please go ahead. I have not yet. There's a question from Eric Stasig, former Ericsson, now independent consultant. And he says, thank you, Judge Hoffman, for taking your time to present this very interesting idea. My question is, why would Court A set a global rate if Court B would only set a national rate for territory B? Global rates based on comparable licenses are blended global rates, which already to some extent take into account are weighted by regional differences. Would it not make more sense for Court B to set it on global rate and then calculate rest of the world based on the weighting you propose? Yeah, all of this, we're gonna keep note of these questions and just think
point,
all of this further through also.
Now, the point is that I think every court shall have the possibility and must obey its own law. And so it must have the possibility to do a global rate setting as if it would be the one and only court that comes to do so, and no other court would have to decide on it. That's that's what its own law says. Just with one exception, if one court has already set up a rate, of course, for its territory, then the second court shall respect this rate for this one territory. And and also the second court shall have the possibility to set up a rate on their own, based on their own law for its own territory. And I think that's something that both courts can respect with each other. And there's no need for calculation. It's just that both license terms from both set up by both courts are adjusted so that for the territory A and B, you have equal license terms set up by the courts of the respective territories. The process of calculating the royalty according to the weighted average is only necessary for the territories where you have no court yet decided a Frand rate for its own territory.
Mm-hmm. Then there's a question from Temi Ananios, who works for Continental in North America. And Tim is asking, should the GDP of country C be applied to determine the rate in country C?
No, I don't think so. Because you have no determination of a Frand rate from country C.
Mm-hmm.
The point, the effect of the GDP is that you weigh the rate setting by a court in order to have the effect that a court that has jurisdiction over a large territory with a big GDP has a bigger weight than a court that has only jurisdiction for a small territory with a small GDP.
Mm-hmm.
And in my example, the territory C is a territory where no court has yet determined a license rate. And so there's nothing there's nothing that you can multiply with.
Mm-hmm. 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 Then there's some, it's very unfortunate, there's an anonymous question, several anonymous questions, which is always difficult to answer because you don't really know where this is coming from. But I'll try to summarize them. They mainly relate to patent pools. And there would be one question about, for example, would a rate adjudicated for a patent family by relevant, Would a rate adjudicated for a patent family be relevant for an entire pool? So you have the rate set on the basis of one family. Would that apply to the entire pool? And also, if a court grants an injunction resulting in the defendant paying a pool rate, should the court include this proviso accepting foreign courts to set rates for their country?
Well, the first thing is with the pool. If the pool is part of the litigation, then it is relevant for the entire pool. The important thing is that the parties are the same in both litigations in front of both the different courts. And the thing with the injunction, I didn't find that question. Where did you see that?
Sorry about that. If a court grants an injunction resulting in the defendant paying a pool rate, should the court include this proviso accepting foreign courts to set rates for their country?
I think so. Well, first of all, if you have a license agreement that results after an injunction, then the point is whether this license agreement allows an adjustment. Because if you have no adjustment, no proviso for an adjustment, then the litigation in the second court would have nothing to decide. That's of course a problem, but unless the second court makes something like it would do for a compulsory license. And then you could say the license agreement that has been agreed after the injunction of the first court implies some kind of adjustment, a possibility for an adjustment if you, for instance, if a compulsory license would be issued. And of course, the Frand rate litigations are not litigations that are aiming for compulsory licenses, but you could say that there is some similarity, and that you could think that that you have the possibility to make an adjustment.
Now, I think so. We are seeing here Richard Arnold has been very much talking, Lord Justice Arnold, around this idea about the global mediation center, an international mediation center as a means to come to grips with global rate setting. And he has been strongly advocating this approach. And we are now seeing Judge Fabian Hoffmann, proposing again other ideas to come to grips with global front rate setting, in terms of not even going as far as setting and establishing a new global institution, but finding first an amicable understanding between various courts in terms of how to distribute the power of decision-making processes among various countries. Perhaps either of these ideas may still need some further thinking, analysis, improvement, some further clarification, but I tend to think overall it is a very positive sign to see senior figures in the judiciary, in their personal capacity, start to think about how to address in a peaceful and friendly manner the interaction with one's neighbors. And this is something which I think, especially in the current times, is definitely an idea which is to be applauded and to be thanked for. Perhaps you may need to clean these models up a little bit. I think the 10 questions that we had showed that there's still people would have some questions and further clarifications may be needed. but the mere fact that there's a motivation to sort of like think about how to how to collaborate further internationally on Frand matters and on patent matters is clearly a positive and encouraging sign. So thank you all for joining today. Once again, if you have time and are interested, this is this fabulous event I'm talking about, the 10th IP and Competition Forum, which is going to take place June 26 and 27 in Amsterdam. We have accreditation for continuous professional development. We have a lot of exciting speakers and contributors from business, from the courts, from the law firms here, and we really hope you're going to join us if you have time. Please shoot us an email, info@oxfirst.com, or let us know if you want to get involved. We'd be happy to collaborate and to exchange. I think it's really important to think beyond your daily job into blue sky scenarios for IP and to seeing what's going to be the next big thing. And for this, I'm really thankful for Judge Hoffman for his contribution today and for how much time he put into preparing this webinar. I feel really embarrassed that I haven't done even 1% of your preparation, Judge Hoffman. And I think this pages of analysis you wrote to me in both German and English would deserve to be further developed, but I don't want to push it too much. With all of that being said, thank you very, very much for joining today. I hope you found it interesting. Please do join us in Amsterdam, end of June, if you're not yet on summer holidays. Also, I'm very pleased to say our next speaker will be Judge Alice Salah, who is from the new director of the Arbitration and Mediation Center of the Unified Patent Court. He is a previous Minister of Justice, and he's currently very engaged in establishing the judiciary again in Ukraine, of all the places in the world. And it's a big privilege that he will be speaking and presenting on the Unified Patent Court's Arbitration and Mediation Center, and he will also be a keynote speaker in Amsterdam end of June. So please stay with us. I hope you had a good time. I hope it invited you to think widely and creatively about patents and standards and push out new ideas and new suggestions. And like with everything that's new and that's not yet fully established, it may have also gone wrong, but it is a new idea and it deserves to be played around with and seen how far it can be taken. And IP needs new impetus. We're all about technology, innovation, and creating novel perspectives in the world. So that also needs to hold for the IP system in and by itself. A very huge, big thank you and a round of applause for Judge Hoffman for his fabulous contribution. I really genuinely enjoyed it, and I thought it's a very stimulating idea. I hope it kickstarts new thoughts, new ideas, which is more than you can hope for in life. Have a lovely afternoon and hopefully see you in Amsterdam or at our next event with Mr. Salah on the UPC's Arbitration and Mediation Center. Thank you again very much. Goodbye.
Bye-bye. Thank you very much for the opportunity.
Thank you. Okay. Bye. Bye.